Hi, and welcome everybody. Today we'll be talking about how to transfer inheritance after someone passes away in Louisiana. In the next few minutes, I want to go over with you some of the basic steps that are necessary in order to transfer assets from someone who's passed away to their heirs. Now, this is meant for situations where the heirs are fully cooperative and everybody's getting along and there's no contested issues of law that have to be resolved. This is meant to give you a basic understanding of the Louisiana succession process and what's needed to transfer, for example, a piece of real estate or a bank account or a vehicle. My name is Brad Scott. I am a probate and estate attorney with Scott Law Group. My team helps hundreds of families every year with succession issues and estate matters in Louisiana. If you're running into an estate problem, there's a good chance we've probably already dealt with it before. If you're watching this webinar today, you probably have someone who's passed away and you're trying to transfer either a piece of real estate, a vehicle, or a bank account from their name to the heirs. You're probably a little unsure what needs to be done, what the process is, how to get started, what information is needed, and whether you need an attorney or not. The purpose of today's webinar is to get you started on the right path and hopefully save you some money and save you some time along the way. What we're going to cover today is some of the basics. We're going to talk about what a succession is and why it's necessary. We're also going to discuss sometimes where one's not even necessary or it can be done without an attorney. We're also going to discuss the basic legal process and paperwork that's needed in order to get it done, kind of what the time frame you can expect to complete it. Don't miss out. At the end, I'm going to share with you some free links to some forms that may assist you in getting certain things done without even the need to have an attorney involved, which will save you some time and some money. So let's get started with the big issue. What is a succession and why is it needed? A succession, or sometimes as it's called as a probate, is just a basic legal procedure that works to transfer ownership of assets, whether that's real estate, bank accounts, or vehicles, from the person's name who passed away to their heirs. Now, it's important to note that a succession is done for a person. It's not done for a particular asset. And the reason why I say that is a lot of times we'll get phone calls from clients and they are primarily concerned with a piece of real estate they want to sell. And they want to get succession done for the real estate. Well, that's not necessarily how it works. What we do is we do the succession for the person. And when we do that succession, we include all the assets they have in their name, whether that's bank accounts, vehicles, real estate, inherited property, anything that needs to pass title, we include all at one time. And it's best to include it all in the succession when you get it done the first time. That way you don't have to go back and have it redone. This will save you some time and some money in the long run. Now, who will inherit will depend on whether or not there is a last will and testament or not. If there is no last will and testament, there are default rules under Louisiana law that provide for who will inherit. If there is a last will and testament, we have to review that document to see what the person's wishes were as far as who they wanted to receive their property. And we follow that. Now, if there is no will, typically what happens if the person had children, the children will inherit the person's property. If there are no children, then it depends on whether or not the property was either community property or separate property. Community property would be property they purchased with a spouse while they were married. A lot of times community property will go to the surviving spouse if there are no kids. If there's no kids and no surviving spouse, then you start getting into brothers and sisters and parents and so forth. You really need an attorney to kind of walk through the family tree with you to determine who's going to inherit the property. Likewise, in a will, depending on whether the will was drafted by an attorney or whether the person tried to do the will themselves, there may be some ambiguity in the will as far as who's supposed to receive what. And again, an experienced attorney can help walk you through that to figure that part out. But for the most part, we're looking to see if there's a will or not a will. If the person had a will, but you can't find it, you don't need the will to open succession if everybody's agreeable. We can just simply open the succession as what's called intestate, and that's when there is no will. And we can follow the default rules under Louisiana as far as who will inherit the property. Now, the next thing I want to talk about is the particular assets that go through probate or succession, as we call it. Clearly, if somebody owns a piece of property and they're on the title, that's something we want to pass, as well as bank accounts. If they are the account holder in the account, then we want to transfer that through their succession as well. Now, we get a lot of phone calls about 401ks or retirement accounts. Those typically have a beneficiary designation attached to them. The beneficiary designation on that, similar to like you would have on an insurance policy or an annuity, those particular assets are what are called non-probate assets. Those transfer directly to the beneficiary when the person passes away, and there's no need to even pass those through succession. So for instance, if you have a parent who passed away and the only thing you're dealing with is a life insurance policy or a 401k or an IRA account, it's more than likely you will not have to do a succession in order to pass that. Typically, all that's needed is you need a death certificate, and then you contact the financial institution who takes care of the account, and they will give you some forms to fill out, and you'll prove the person passed away through a death certificate, and that will transfer those assets directly to whoever the named beneficiary is. Now, the only issue that comes up is if the beneficiary on the product has already passed away and there's no backup or alternate beneficiary, then that product, that IRA or that insurance account will be passed directly to the estate, and then we'll go through the probate process. And whoever would have normally inherited through the succession will inherit that product, even though there was a beneficiary previously, since that beneficiary passed away. Again, that's only a situation where there is no alternate beneficiary listed. More likely than not, in typical situations, a husband will leave it to their spouse, and if the spouse predeceases or passes away before, then it goes to their children. As long as you have those designations on the beneficiary, you probably will not be dealing with that particular item in the succession or the probate. Another issue that frequently comes up when you're dealing with co-owned property. Let's take a situation where there's a husband and wife, and the husband passes away, but he has a last will and testament saying he's leaving the home to his kids. Well, we can only transfer what the actual person who passed away owns. So if they only own 1/2 of that property, only that 1/2 is going to pass through the succession. That other co-owner, whether it's a spouse or another family member or something of that nature, they're going to continue to own their portion outright. They're already on the title. The only thing that we're going to transfer is the amount or the portion that the person who passed away owned. So this comes up a lot when you have inherited family property. You may have a situation where it's your parent who passed away, but they inherited property from their parents, your grandparents, and that property may be owned by 5 or 6 cousins or uncles and aunts. But when we do the succession, the only thing that we are transferring is that particular percentage of the property that your parent owned. We're not going to be affecting the entire property. So that's important to keep in mind, that we can only transfer what the actual person owned and only their percentage. A lot of times we'll get calls where the person says, look, Dad left me the property in his will. My mom passed away many years ago. I want the property. Well, yes, you will get Dad's portion of the property, but Mom's portion of the property may go to all the kids. So even though you were named in Dad's will, you still may end up co-owning it with your siblings. And an experienced attorney can kind of walk you through that scenario and figure out exactly what you will be inheriting from the estate based on the circumstances of the facts of your case. So those are really the main basic concepts you need to know as far as what a succession is and what property passes and basically who inherits. So the next thing we want to talk about is the actual legal process or the procedure that's necessary to accomplish that. Selecting the best legal process to use is very important. And what a lot of people don't know is there's multiple ways to conduct a succession through the court process or even outside the court process. Picking the right legal process from the beginning is going to save you a lot of headache and, more importantly, a lot of money. Too often we see people get off on the wrong path and they get tangled up in a succession that goes on for maybe years. It becomes very expensive, when in fact that succession probably could have been handled in a matter of a couple of weeks had it been opened properly and the right process was chosen from the beginning. So that's what I'm going to go over with you now, is kind of what the options are, what the various procedures are, and how to basically select the right procedure based on your circumstances. So what you need to know is that there are basically 2 main types of procedures that you can utilize to do a succession in Louisiana. The first procedure is what's called a simple possession. This is where we simply take the assets that are owned by the decedent and we pass them directly to the heirs. This is a very quick a very easy procedure for the most part as far as legal procedures go. And that usually can be accomplished in a matter of a couple weeks after we get all the information from the person who's hiring us. Now, the second procedure is probably the one you've probably heard of before and you're maybe more familiar with, is what's called administration. And that's when a representative or an administrator or an executor is appointed by the court to take care of the estate. And that person's job is to collect the estates, take care of things, maybe sell what needs to be sold, pay bills or liabilities. And then after some time, then what they do is they close the estate and they'll make a distribution to the heirs. Now, this administration procedure is a lot more drawn out and it's a lot more expensive because there's a lot more that needs to be done. However, we don't really need to do an administration of an estate unless there's a reason to do so. What we like to try to do is always try to find a way to do it as a simple possession first. And only if we run into some difficulty, then we kick into administration. So for example, if everybody is cooperative and the only thing you want to do is pass the ownership of a house so you can sell it, then there's no need to put an administration. We can simply transfer the ownership to the heirs, and then the heirs, after the succession is completed, as co-owners of the property, can simply put the house on the market and sell it and take care of it that way. We don't put people in administration unless there's a need to. And again, the scope of this webinar today is covering situations where everybody is cooperative. So what we're contemplating that as a simple possession is what we can use to take care of that succession. Now, just for a quick example of when an administration might be necessary, this is a very common situation we come across with people calling our office. Let's say you have a situation where there are multiple kids involved. There's 2 or 3 kids, but unfortunately one of the kids is living in the property and it's very unlikely they're ever going to agree to selling the property where everybody else is ready to sell it and get rid of the property. Well, if we just did a simple possession and we passed the property to the heirs as co-owners and then they wanted to sell it, they're going to need the consent of that person living in the house in order to sell it. If not, they're going to be right back into another legal action fighting over the property. If you have that kind of situation, and again, this is where there's not full cooperation, it might be best to place the succession under administration. And then what can happen is the person who's appointed as the representative of the estate or the executor, they can go ahead and sell the property themselves without necessarily having the full cooperation of everyone. And once that money comes in, then they can distribute it to the heirs. Sometimes the administration provides a better way for us to accomplish that rather than going through a simple possession. Again, however, we do prefer when there is cooperation because it allows things to be done a lot quicker and a lot more cost effective for the client. But that is just one example of when an administration may be necessary and you wouldn't be using a simple possession like we're talking about today in this webinar. If you're interested in finding out more information about the administration process, go to our website, www.louisianasuccessionattorney.com. We have other free resources and videos and webinars on that site that discuss administration specifically that can kind of walk you through that process and give you some more information on whether that process is right for you or not. So again, for today's purposes, we're talking about estates where everybody is cooperative and we're just wanting to transfer the ownership of the assets to the heirs using a process that we call a simple possession. Now, where we want to start with in order to determine what's the best process to use is we want to know what the value of the estate is, or the approximate value. And the magic number here that we are dealing with is $125,000. If you're under $125,000 under the laws of Louisiana, we can handle the estate as what's called a small succession. Now, this is very beneficial because using a small succession procedure, we do not actually have to go to court or open the succession in court and have a judge approve it. The paperwork can be drafted and signed by the heirs, and then that paperwork can be used to transfer assets as it's needed. Now, again, keep in mind that as far as valuing the estate, we're only dealing with the percentage of ownership that the person who passed away had. So let's give you an example. Let's say there's a husband and wife who own a house together that's worth $200,000 and the husband passes away. The property is worth $200,000, which is over $125,000. However, the part that the husband owns is only 1/2. So really the value of his estate would be $100,000. Which would put us underneath that threshold for using a small succession affidavit process, which is the $125,000 value. I know a lot of people mess that up and they think they are actually over the threshold for using it, when in fact, once we look at it and we realize they're only dealing with the percentage owned by the decedent, then they are able to use that process and save some money and get done a lot quicker. Now, what happens if you're over $125,000 as far as estate value? Well, if that's the case, then we do need to what's called judicially open the succession. And this means that legal pleadings need to be drafted and signed by the parties. And then those pleadings need to be filed with the court and then presented to a judge for approval. Now, the end result of that process is what is called a judgment of possession. And if you start asking around with banks and stuff like that, and you're trying to get things done, they're going to ask you if you have a judgment of possession yet. That judgment of possession is a judgment that's issued by the court based on the pleadings that are filed by the attorney on your behalf. And the judgment of possession basically identifies the person who passed away, stating that they passed. It identifies their assets, and it also identifies the heirs who are inheriting it and recognizes them as an owner. Once you get that judgment of possession, that's really your title document. That's the thing that proves you own the property or the assets from the person who passed away. If there's real estate involved, we take that judgment of possession and that is recorded in the land records, and that's basically like your act of sale that proves that you now own the property from your parent or whoever it is that passed away. Likewise, that same judgment of possession can be then presented to a bank, and you can close bank accounts and get those dollars transferred over. You can also take the judgment of possession and bring it to the DMV and take care of any motor vehicle or an RV or anything of that nature that you need to transfer ownership with. So when we're opening the succession judicially, the end result or goal that we're trying to obtain is to get that judgment of possession signed by that judge, so then that can be used to take care of the assets and move them over to the heirs. Now, once they transfer the title to the property to themselves, those heirs co-own it. And as co-owners, they can do whatever they want with it. They can lease and sell the property if they want. They can keep the property for their own use. Between themselves, they can buy each other out, or whatever they want to do with the asset is then possible. But you need that part of the process, you need that succession process to transfer that ownership. And I'll note that a lot of people confuse a last will and testament as being all they need to transfer ownership. The will does not transfer ownership. The will only provides the instructions for what the person who passed away wants done. We still have to enforce that will or carry out the wishes in that will, which usually means we have to probate the will, and then we have to ask the court to place the heirs in possession. And we see this a lot of times where somebody may have passed 20 years ago and the kids think they own the property because the parent left the will, but in fact the ownership never transferred. They still have to go through that succession process. And we always recommend doing this sooner rather than later. The longer you go without doing this process, the more people that can pass away, the more difficult the ownership structure can become. We have many calls where it's 5 or more generations of people who have passed away and they haven't done successions for them. And here we are having to do 5 or 6 generations of successions, and then the information gets a little difficult to obtain and get done. So get it done rather soon. Don't put it off. It is something that's easy to put off, but usually what happens is something will happen that's going to force your hand, and then you're going to be at the time crunch to get it done. For instance, we see the situation whenever there's a hurricane that comes through the area. If there's any kind of federal monies that need to be handled, or grant money, or if there's an insurance claim that needs to be made, the first thing they're going to be asking for is proof that you own the property. And if a succession needs to be done, then you have to be rushing through that process before your claim can be made and you can receive those funds. So again, it's better to get it done sooner rather than later. So that's basically an overview of the succession process, as far as what a succession is, who inherits, and then kind of the basic options you have as far as handling the estate. Now, the most important thing I can recommend to you at this point is to try to find an experienced succession and probate attorney that you can talk to go over the particular facts that you're dealing with. There's a lot of issues such as forced heirship, usufruct, things of that nature that we're not covering in this webinar today that may be an issue in your estate. There may be reimbursement claims by a spouse that need to be dealt with. An experienced succession attorney can walk you through those things and give you some recommendations on what's the best way to handle the estate. As I mentioned earlier, my team handles hundreds of estates every year. Usually what happens is people will give us a call and we have about a 15 or 30-minute initial phone consultation, which is free, at which time we'll go over their situation, and the end result is we're going to make recommendations to you on best how to handle the estate. And we're also going to give you a ballpark figure as far as what's going to cost, and you have the ability to move forward that day if you want to. Now we're mostly set up electronically these days, so most of the time our clients aren't even coming into the office. We can handle a lot of things through email and through FedEx. Believe it or not, a lot of our clients actually come from outside the state of Louisiana, so they're not able to even come into the office, and they don't want to make that trip. So we'll do whatever's easier for you. If you want to come in and sit down with us and go through the paperwork, we absolutely can do that. We welcome you to come in and meet you before we start working with you. Or if it's more convenient for you to handle things over the phone and talk to us that way, and we can exchange documents via email, we can also do that for you as well. But typically the process is we will send out a retainer agreement to you for you to review and take a look at. If you have any questions, you can give us a call back. Once you retain us, then we will collect the information we need from you to open succession. And this will be, collecting the family tree information, the decedent's background information, the names and contact information for all the heirs. If there's a last will and testament, we're going to try to get a copy of that from you. Then also getting a listing of all the assets that need to pass through the succession process that we're dealing with. Now, if you don't have any of this information, or you only have bits and pieces, that's fine. We will help you obtain that information. For most of the courts in Louisiana, we do have online access to their property records, so we're able to pull titles to property that way. So it's not something you're going to have to go down to the courthouse to obtain. Give us what you have, and then we will work from there. Once we get all that information, the drafting process starts on our end, and we're going to prepare all the documentation that's necessary to open the probate process and obtain that judgment of possession for you. Once that's drafted, we are going to have to coordinate with you to get some documents signed, and again, that can be done via FedEx. We can send those to you. You can sign them and send them back to us. Once we get all that back from you and get all those documents, we're going to process that for you. We're going to pack it up. We're going to have to go down to the courthouse or send it to the courthouse and pay the filing fees, and it will go through the process in the court. Now, for most of the successions that we're talking about today, simple possessions, that's usually only a few days as far as time frame in the court. Once the clerk of court processes the documents, they're sent to a judge. And for the most part, if we have all our ducks in a row, the judge is going to sign the judgment of possession the same day or within a couple days of being put on his desk, his or her desk. Once that judgment of possession is signed, it's sent to us, and then we will process that, let you know we received it. And then we can also assist you on transferring the title to any vehicles or anything else that you need to close as far as bank accounts. And the most important thing is we're going to take that judgment of possession. We will record it in the land records for you if there's any real estate involved. Once all that's done, we will send you copies of everything, and that will basically complete the succession process. So that's the overall process. And again, the key to getting it done is getting some good legal advice on the front end and getting started on the right path. Now, there are certain situations where you may not need to use an attorney to get this done. For instance, if there is a bank account that the decedent owned and it has a value of less than $5,000, and that's the only thing that you're dealing with, it probably doesn't make sense to incur the expense of an attorney to get that done. There actually is a process under Louisiana law that allows you to complete and fill out an affidavit, which contains all the information about the decedent and the heirs. And the bank is supposed to, based on an affidavit, release the funds to the heirs or to the surviving spouse. Okay. Now, we'll tell you some banks are a little reluctant to do it that way, and they're going to press you to do a succession in order to get it done. However, you at least want to try this option first because it's going to save you some money. So what we're going to do is I'm going to put a link, it should show up on the webinar here, to a page on our website where I'm going to have that form downloadable for you. You can go there and download it, complete it yourself. It does need to be notarized, and go ahead and try to take care of handling the estate that way if the only thing you're dealing with is a bank account that's under $5,000 in value. Same thing for a motor vehicle. If it's just a car or truck that they own, and that's the only asset they have, the DMV actually has a similar procedure where an affidavit can be completed and provided to them, and they will transfer the title based on that. Again, there's no need to open succession or probate. You just complete that document, you get it notarized, and then you can present it to the DMV to take care of the title. Again, the same website that I'm going to put on this video, you can go there, and we're going to have a copy of that as well, where you can download it for free and try to handle the estate that way. Of course, if you have any questions or run into any problems, or the assets are more than that, or the bank won't cooperate, feel free to give us a call and we'll do our best to try to help you as best we can. That pretty much wraps up our webinar for today. If you have questions or you need the assistance of an attorney, please give us a call. We're more than happy to help you. Also, if you need some more information, again, check out our website, www.louisianasuccessionattorney.com. We have books and reports and other videos and articles on there that can help you figure out the process that you need to go through. Thank you for joining us, and take care.